advance, and I forwarded that to you in your email, so you can look out for that. I cannot remember. Okay, so I'm going to share screen with you. This is the most stressful part of giving a presentation. Is the technology component. So, I want to make sure that you all can see my screen.
Yes.
Thank you for the nods. Now, if my remote works, we'll really be in business. So let's hang on. Actually, my remote is not working. Give me 2 seconds. All right, no problem. I can manually control it. Okay, so welcome everybody. Thank you for joining us. I will get started. And like Kayla said, if you have a question, just put it in the chat and we will get to it at the end. So here's a little bit of background about me. Not the most exciting. My newest appointment is I was appointed to the Fairfax Police Civilian Review Panel. And Chairman McKay said he really wanted to get somebody with a disability background on that panel to make sure that disabilities are protected and treated appropriately. So I'm excited about that new endeavor. So as we know, raising children is a journey, not a race. And so you have to fasten your seatbelt because it may be a bumpy ride. And I know because I have 3 children of my own. And when I first started giving presentations, this is what they look like. And every time I've gone to try to update their photos, I've stopped because I just like to remember them at this young age. So I have 3 children, and now they are, my oldest has a master's in psychology. My middle one is attending Goucher College, and my son is a sophomore at Miami University in Ohio. And then, of course, my favorite children, my 2 dogs, who you might catch a glimpse of at some point. They like to hear about special education. So this is something I learned when my oldest was in kindergarten. The principal said to the parents, you are your child's advocate and nobody should tell you otherwise, and nobody should fault you for advocating for your child. So I fully embrace that. So there are 3 main laws that will protect your child. There's Section 504 of the Rehabilitation Act of 1973, Individuals with Disabilities Education Act, we call IDEA, and then of course the ADA. So like I said, I'm a parent, and this is what I felt like when I was navigating the special education maze. My husband and I are both attorneys, and when we tried to get special education services for our child, the school district, let's put it this way, we were sitting ducks. And so we're both attorneys, and we felt like we were knowledgeable, and we were consistently told that she didn't need any supports or services, even though she was on the spectrum. So Fairfax County, I think, has come to regret that choice because they ended up giving her an IEP and creating 2 special education attorneys with a firm in Fairfax. So I understand. So it's really an easy process, right? Just a couple acronyms, you know, some doctors, and then you get some tests and you figure out what category. Yeah, it's really complicated. And my mantra for 2021 is imbalance of power. And there's a tremendous imbalance of power because the school districts, all those acronyms on the screen, the school districts know what those initials and acronyms stand for. And as parents, it's very daunting. So it's really great that you're educating yourself on how to navigate the process because the school system knows how to do it every day. So I say, keep calm and send an email. If you don't know what to do, if you don't know where to go, send an email to your child's teacher saying, I have concerns, my child might need special education. And I always say send an email because as a lawyer, I want to have that documentation. I want to have a record. So even though you can make requests verbally, you can request special education process verbally, you have no record of it. And in the legal world, if there's no record, it's not memorialized and it was as good as never being said. So I strongly recommend that everybody keep records, not these kinds of records, which my children know nothing of, but these kinds of records, files. I recommend that my families keep a 3-ring binder and just put all the records that you receive in the binder chronologically. And then I put tabs and labels on the files so I can find them easily, but keep them all chronologically. And when you receive a new document, I always write on the top the date it was received. If I received it at an IEP meeting, I will put received pre-IEP meeting or post-IEP meeting. So I make sure I keep good records and then just punch the 3 holes and put it in. And you'll be really grateful if you start that at a young age, because there are a lot of documents over the years. And you want to make sure you keep all the records. That doesn't mean that you can't get the records from the school, but you want to keep the records as best as possible. So this is the 3-ring binder. And again, I always say keep everything chronologically. Some people like to keep it by category, but I find if you keep it by category, when you go to IEP meetings, when your child's older, you're carrying multiple notebooks with you. So I and of course, at the firm, we scan everything in. So I can, at an IEP meeting, I can pull anything off the cloud if I need it. So I'm just going to briefly talk about Section 504. Most parents tend to want information about IEPs and IDEA. So a Section 504 plan will provide access to the child's learning environment. It can provide services. So school districts don't seem to understand that, but you can get services through an IEP, but it's not required, through a 504 plan, but it's not required. And those things, those categories on the left are just examples of conditions that you might seek in a 504 plan for your child. So for eligibility, what can you expect for the 504? It starts with a referral, and a parent or school staff can submit a request for a 504 plan. And it's a similar process as an IEP. A local screening committee determines if they're going to move forward with an evaluation. They can also just give your child a 504 plan immediately. I've had situations where they've given the plan and then done the evaluations. They're technically supposed to do evaluations for your child. And it's really important because there can be additional disabilities or comorbid disabilities. So a good reason why you might pursue a 504 plan is if your child was evaluated under IDEA, but they weren't found eligible, they might still be eligible for a 504 plan. So at the eligibility meeting, there will be a committee, and the requirements are not as stringent as they are for IDEA. For IDEA, for an IEP, there are a lot of procedural safeguards. There are not the same procedural safeguards for a 504 plan. So again, for eligibility, the committee has to review information from a variety of sources. And if the child is found eligible, a 504 plan is drafted. And again, 504 is equal opportunity to succeed compared to the same age non-disabled peers. What's important to know about a 504 plan is that Section 504 and the ADA are what will protect your child after they graduate from high school. So if they go on to any kind of post-secondary education or in the workplace, these are the laws that will protect them. So an IEP doesn't continue after graduation. So if your child's going to go to college, they are going to provide the college, usually the college wants to see recent testing, recent assessments. So like a psychological educational assessment, and then they will provide the student with accommodations. So in order to be eligible, they have to meet the certain requirements. Does your child have a physical or mental impairment? Does that impairment limit one or more major life activities? And that could be something as simple as learning, or it could be a disability that causes fatigue. It's very, very broad. And is there a record of the impairment? So that would be as easy as having your doctor write a letter saying, you know, Billy has ADHD and he needs accommodations at school. So it's like I said, there is no age limitation on Section 504. And so this is what your child will use when they're in college. So here's some examples of accommodations for a 504 plan. And this is just the tip of the iceberg. It can be pretty much anything. But I like to make sure that it's as detailed as possible. For instance, preferential seating, that can be interpreted in many different ways. Preferential seating could be next to the bathroom for a child who has colitis. It could be away from distractions. It could be next to the water fountain if the child needs to have drinks frequently. So be as specific as possible. So here is a sample Section 504 plan. You know, it's different. You'll see it's different than an IEP because there are no goals in it like there would be in an IEP. But you would have the area of need and what will happen. So it could be like the first one, organization. The student will have to have a check-in at the end of the day. So it's not necessarily just physical changes to the school. It can involve support from staff. So here's just a quick chart, and I'm going to make the presentation available to Jan after so you can have this because it's a lot to read through at one time. But these are the major differences between a 504 plan and an IEP. And what I think is really most notable is the fact that the recovery is different. So under 504, it's not easy, but you can recover monetary damages if there's proof of a knowing violation. But IDEA only provides education. So if you had a complaint under IDEA, you're looking at compensatory education. So let's turn and talk about IEPs, with Individualized Education Program. And here is what the special education process looks like under IDEA. And you can see it's a very formal process. So it starts with a referral. And like I said before, anybody can make a referral. Your next door neighbor can make a referral. A teacher can make a referral. A parent can make a referral. And again, the referral does not have to be in writing, but I strongly recommend that you do. So here's an example of a referral form that I just pulled down from the Virginia Department of Education website, the VDOE website. So if you go onto the VDOE website, they have, if you search Virginia Department of Education, special education forms or documents, the forms will all come up. There's one document that has all the forms. And so here's a sample referral. Some school districts have their own referral form. It doesn't matter. You could write in crayon if you wanted. I don't recommend that unless you keep a copy of it. But that's why I like emailing, because you automatically have a copy of all of your communications. So here's the referral form. And then what happens is there is what's called the 65-day eligibility process. So it's 65 days in Virginia. I know Prince William likes to self-impose a shorter process time just to make sure that they comply with the law. But 65 days is 65 business days. So it actually amounts to about 91 calendar days. So if you recall my earlier screen that says send an email, send the email because you want to start that process. The process takes a long time. So start the process. So the first step is the referral is received by the special education administrator. And then the special education administrator has 3 options. They can automatically begin the evaluation process. I don't think I've ever seen that happen. They can refer the student to the local screening committee. That's usually what I see. Or they can deny the request. If they deny the request, they have to provide the parent with the document called prior written notice. Usually what happens is B, option B. Then the local screening committee will meet within 10 business days. So the local screening committee has required members. It must include the parent, the principal or their designee, teacher, specialist. The committee reviews the child's performance, including any responses to interventions. So if any interventions were provided to help your child, they'll look at that. And then they'll make a determination if they need to do assessments and evaluations of the child. So that's really the gatekeeping meeting where they decide if they're going to move forward with the process. So if they decide that your child will be evaluated, this is usually the basic battery of tests. So a psychological, sociocultural, which is usually an interview by the social worker with the parent, an educational assessment, speech or language if appropriate. They usually do a hearing and a vision, occupational therapy if it's appropriate, physical therapy, classroom observation, and a possible medical examination by a doctor. So again, they have the eligibility process must be completed within 65 business days from the date of the receipt of the referral. So the referral would be the document that was sent that started the process, not the local screening meeting, but the document that was sent to start the process. So at the eligibility meeting, the committee will use information from a variety of sources, including from the parent. So IDEA was written to make sure that parents are critical members of the IEP process. And so your input is critical in an eligibility process. The law says they have to use information from a variety of sources. So they just can't do, for instance, a classroom observation and say, Billy has ADHD, but I don't see it presenting in the classroom, done. They have to use a variety of sources. And this is really important. The evaluation reports that the school district does must be made available to the parents at least 2 business days before the eligibility meeting. So the language is very clear. It says made available to the parents. So technically they only have to allow you to come to school and view the reports. That doesn't usually happen, but what I recommend to parents is to send an email. Again, you want a record, send an email saying, I would like a copy of all evaluation reports at least 2 days before the eligibility meeting. So again, IDEA requires parental participation, meaningful parental participation. So as a parent, you are a required member of the meeting. And of course, there are exceptions if they can't get the parent to participate, if a parent refuses to participate, that kind of thing. There are exceptions, but it's very interesting because the law has always said that parents can participate using alternative means, such as telephone and video conferencing. So it's very interesting because now we're seeing that in use. We're seeing regular video conferencing for IEP meetings and eligibility meetings. So again, you want to have the required members of the IEP team. And if you're not satisfied with the reports that the school district did, you can request what's called an independent educational evaluation. And you do that by sending a letter to the school district saying that you don't agree with the assessments that they did. You do not have to give a reason why you don't agree, but you say, I don't agree with the assessments and I'm requesting an IEE, which is the private evaluation at school system expense. And the school district must consider private evaluations. So let me see. Okay, so what do they consider for to be eligible for an IEP? So first, the child must have one of the disabilities listed in IDEA. Second, disability must adversely impact the child's educational performance. And third, by reason of the disability, the child needs special education and related services in order to benefit from the education. So let's go through those one at a time to see if the child is eligible. So these are the eligibility categories under IDEA. So you would want to find out if your child fits under one of these categories. There's also developmental delay, but that is for young children under 7 usually. So category number 9, I will point that out. That's other health impairment. So that's obviously a very broad category, and that can include really anything. It can include medical conditions such as ADHD or ADD. It's really the catch-all category. Okay, so what are my tips for preparing for the eligibility meeting? Like I said, you want to put in writing that you want evaluations. Some school districts will do interpretive meetings, and you can certainly request that. So an interpretive meeting is a meeting that you would have with the evaluator. So if the school psychologist did a psychological report, you can request to meet with the school psychologist to discuss the findings and even ask for corrections before, because these reports can be difficult to understand if you don't have a trained person guiding you through it. So the interpretive meeting is a good idea. You want to gather any private evaluations if you have any, but you have to be careful about dates. They will not consider usually longer than 3 years is considered antiquated. But if you had private evaluations, you want to make sure you also tell the eligibility team about that beforehand, because some tests will not be valid if they're repeated within a certain period of time, usually about a year. So any data from home, and that's really relevant. Some teams will say, well, that's at home, that doesn't happen at school. But I see a lot of students who work really hard to hold it together in school, and then when they come home, they collapse. So, or they're just exhausted. So it's very relevant. If your child is spending 2 hours doing a homework assignment that classmates are spending 30 minutes on, that's really relevant. So I always, tell parents, find out how long the homework assignment is supposed to take, and after 30 minutes, draw a line and tell your child that they're done. And then keep a copy so you have a record showing what the homework situation is. So again, you want to gather all your data and be prepared. So again, here's a suggestion. If you go back onto that VDOE website and enter special education documents, you can pull up the worksheets. So the operational criteria worksheets, and this one I think is for OHI. I can't actually see it because there's a header on my computer right now for screen sharing. So I think it's an other health impairment. Yes, it is other health impairment. So go through this before your meeting so you are familiar with what you need to check off. What do you need to support? And I will make a list for my clients before the meeting and for each step. And I'll say the psychological report on page 3 says this. The educational report on page 2 supports this because of this. The teacher narrative supports it because of this. So I will make sure that the children are found eligible in the appropriate categories. And some people ask me about that as well. How important is it to get the appropriate category? And I will tell you that the law says that the IEP follows the child and not the eligibility category. But I like to look at the category as sort of like the title of the book that is the IEP. It's the first thing that they look at. And so it really describes your child. So I would want that to be as accurate as possible, and they can be found eligible in multiple categories. I've also had teachers say things like, knowing the category knows how we can teach the child. And I don't agree with that either. Again, everything is supposed to be very individualized. It's the I in the IEP. And so it's not appropriate to determine how a child is to be educated based on their category. But that being said, that's why it's important to have correct categories. So the second component is, does the disability adversely impact education? And education is a giant umbrella. Some schools try to say that it's academics. They'll say that the student has all A's and B's, therefore they don't need an IEP. But that's really not appropriate. The social skills, behavioral skills, physical skills, those are all educational. There includes academic and non-academic skills. And for instance, a child who has social skills deficiencies may not be able to work on a group project. And as we know, group projects are really important. So there are lots of ways to look at impact on education. Again, it's not just academic grades. So advancing from grade to grade is no longer a criteria. I put a copy of the regulation there. So anybody who has questions, because this seems to be a common issue and this is really what happened to my child. They said she has all A's and B's, she doesn't need an IEP. but we were not really worried about her academics. So the third criteria is by reason of the disability, the child needs special education and related services in order to benefit from the. So this is the big difference between IDEA and Section 504. A child who's eligible under Section 504 doesn't require special education and related services necessarily. So what is special education? It's specially designed instruction that meets the unique needs of the child. And it doesn't have to be academic. Again, it could be social skills. It could be academic. It could be executive functioning. It could be a child who doesn't know how to keep a calendar or how to break long-term projects down into smaller parts. It could be a wide variety. Then related services, transportation, developmental, corrective, speech. Also, I'll point out that educating the parent is a related service. So you can, as a parent, get support from the school district. So for instance, a common area would be assistive technology. I have a lot of students that use assistive technology, whether it's AIM Virginia or an AAC device, and parents can get training on that. So the child doesn't have to figure that out alone. So what happens if you go through this process and the child is not found eligible? What can you do? Well, you can appeal the decision. You can request mediation, or some school districts have what's called an administrative review. I'm not a tremendous fan of administrative review because administrative review is when they have supposedly impartial other school employees determine whether your school staff made the correct decision. And I found more often than not, they find that their fellow staff members made the correct decision. So, but you don't have to rule it out. You can, again, seek the IEE to help document that your child does have a disability and has challenges, and you can file due process. So what happens if your child is found eligible? Yay. And I remember the day that my daughter was found eligible, and we had fought and fought and fought. And, this picture really captured it, because I was like, it was like a storm, and then there was like the light, but it was also disheartening because it was like confirmation that yes, she did have disability and she did have struggles. But my philosophy is that if that's the case, then you need to get help, and your child needs help in school. So what happens next? So if your child is found eligible, then within 30 calendar days, the IEP team must develop an IEP for the student. That means they would have to convene an IEP meeting of which you are an integral member. So the IEP team collectively determines the content of the IEP. So the present levels of academic and functional performance, which I usually call the PLOP. The PLOP is very important. The PLOP talks about what your child's strengths and weaknesses are. It should also talk about your child's rate of progress. Are they able to make progress, and how quickly? So that way you can determine what the goal, a reasonable goal will be. Well, not reasonable, but an appropriately ambitious goal. So the PLOP, the areas of need that are described in the PLOP will turn into the goals. So that's really important to understand. So you want to make sure you document any areas of need. And again, as I said before, the IEP does not have to follow the eligibility categories. So if, for instance, your child was eligible under blindness, but they were having anxiety at school, they can get services and they can have goals for anxiety, even though they were found eligible for being blind. So the services and supports and goals follow the child, not the category. So there will be the measurable annual goals, and some students have short-term objectives within those goals. There's a section on services, and there's a section on accommodations or modifications. Beginning at age 14 or earlier, transition goals, which are really important. Will your child participate in state and division assessments? And if they do, will they have accommodations? It's very important that the students have accommodations throughout the year and before they take something like an SOL. You don't want them to get accommodations for the first time on an SOL. You want them to be proficient using the accommodations. The team will determine the least restrictive environment. So when you hear people talk about inclusion, that's what the law says. The law says least restrictive environment. That's what inclusion is. And then you'll get a document called the prior written notice, which is required anytime the school district proposes a change to your child's educational plan or anytime they refuse to make a requested change. So there are a lot of resources for writing goals in an IEP. Over time, it gets a lot easier. I'm very proficient at it these days. I can discover an area of need during an IEP meeting and come up with a goal really quickly, but it just takes some practice. So you can ask for proposed goals from the student's case manager. And the important thing to note is that the goals must be, the team must be willing to consider your ideas. So there are teams that will send parents draft IEPs. It's not recommended for the team to put service hours and placement in the draft. Those are areas that really should be up for discussion, but it's okay to get proposed goals from the school, but they need to show a willingness to accept your input on those goals. You can also draft your own goals. That's how I started out, drafting the goals that I thought were appropriate. And actually, I remember for my daughter, I came into the meeting, I think they had 1 or 2 goals for her, and I had 7 or 8 goals. And after the meeting, the school social worker contacted me and she said, "Can I get a copy of your list? Those were the best goals I've seen." So, it was very helpful for me to write those up in advance. I really do like a self-advocacy goal. I think that's critical for all students, that every student needs to be able to self-advocate. Especially if you think about a student who's going to college, an IEP is no longer available to them, and 504, there's no affirmative duty on this. Like an IEP, the school has an affirmative duty to make sure that your child gets the supports and services. In college, 504, the student must request. So the student's going to have to go up to the professor and say, "I have supports and I need extra time," or "I need shortened assignments." So they have to have a self-advocacy goal. I think it's really important. You can also, what I've done with some students is the IEP talks about how the goals will be measured. Sometimes I will put in that it'll be measured by the teacher and by student checklist, because the student can really help support progress on a goal if they know what they're working on. So student checklist can be really helpful. So there's an acronym. You want to make SMART goals. Make sure they're specific, measurable, achievable, relevant, and time limited. So again, an IEP goal is what you think your child can accomplish in a year. So the goals are for a year. Again, you can have short-term objectives. And if your child is on a VAP track, the Virginia Alternative Assessments, then they must have short-term objectives. But you can have short-term objectives to break down the goals if that's important. But the idea is to make sure that the goals are appropriately ambitious for your child to complete in a year's time. So here's 2 places where I've seen some pretty good goals, sample goals, and there's hundreds of them. And again, Jan will make this available. I do have a Virginia Standards of Learning app that I bring with me to all IEP meetings, so I can look and see what the grade level skills are for each grade. So I know what the students are supposed to be working on for that specific grade level, and it's broken down by reading, math, science. So I would be remiss if I didn't discuss the Andrew F. case. That was a landmark decision by the US Supreme Court in 2017. And what's important to know, I would love if everybody took it and read it. It's not very long. It's a really important case because it says, it really emphasizes that the IEP must be unique to your child. So schools must offer an IEP that is reasonably calculated to enable a child to make progress appropriate in light of the child's specific circumstances. It also says that the goals must be appropriately ambitious. So if you've heard the phrase FAPE, your child's entitled to a free, appropriate public education. If your child is a child with a disability, they are entitled to a free, appropriate public education. It's really, I say now, a free, appropriately ambitious public education. So it actually strengthened the cause, strengthened the need to give children with disabilities a strong education. It's not just a de minimis education now, it must be meaningful. And what's really significant about NJF is that it explains that school staff must provide a cogent and responsive explanation. So schools just can't willy-nilly put in goals or put in a random number. So that's something that I tend to have issues with in IEP meetings, is I will ask the school staff, well, what's the baseline? You know, you're saying that you want the student to read 50 sight words by the end of the year. Well, how many sight words does he know now? That's really important. If he knows 45 sight words right now and you're saying he'll know 50 by the end of the year, you're giving him a goal of 5. That's not appropriately ambitious, most likely. So it's really important, especially in this time of COVID, it's really important to make sure that your child's ability to make progress is documented in the IEP. So let me see. I don't know what my header says. Anyway, oops, now I skipped. Let me go back. So the purpose of the IDEA is to ensure transition. The purpose of IDEA ensures that all children with disabilities have FAPE, because the ultimate goal of IDEA is to prepare children with disabilities for the most independent life as possible. And I bring that up regularly at IEP meetings. How are we preparing this child for as independent a life as possible? So as I stated earlier, starting at age 14, there must be a transition plan. The biggest pitfalls that I see are that the transition plans tend to be rather superficial, and they don't have meaningful goals. And I think transition starts way earlier than age 14. I know with my own children, and before I was working full time, I said, you know, I was a professional school chaperone. I would always have the kids talk to the wherever we were about the occupation. So even before COVID, I did the 8th grade court tours, and I would always make sure that the sheriff and the judge always talked about how they got to where they were. So I always think exposure is the most important way. But the child needs to have meaningful opportunities to explore future life. So these are some of the things that I look for, and I will give parents a form to fill out and ask them, can your children do these things? Can your children do their own laundry? Can they wake up to their own alarm clock? Do they know how to manage a checking account? Things like that. And I'll tell you, this list is great for neurotypical children also. A lot of children who go off to college are not prepared to do all of these things at once. So I think it's really important to start kids early, as early as possible. I'll tell you, my own children, when they were invited to birthday parties as early as 2 years old, I would have them call an RSVP. We probably don't RSVP anymore by phone call, but it's probably a lot of evites. But I used to tell my kids, I'm like, I wasn't invited to the party, you were. So you have to call Mrs. Smith and tell her whether you're coming or not. So it's really important to start kids. And medications, kids go off to college and they have no idea where the medications come from and how to call a doctor and how to get a refill and how to go to CVS. So, and these are all goals that can go into an IEP. The IEP can have a goal. Billy will wake himself up. So an IEP will also talk about what is the least restrictive environment. And again, that's the phrase when you hear the word inclusion. The word inclusion is actually not in the law. It's described as a least restrictive environment. And that's a really important goal of IDEA. They want to include children as much as possible with neurotypical developing children. And it's very important, especially when there's behavior problems. You want your child to model after neurotypical children. And also the real world is filled with neurotypical people. So it's really important not to keep them separated and isolated. So the law says that removal of children with disabilities from the regular educational classroom occurs only if the regular class environment cannot, education can't be achieved with the use of supplementary aids and services. So there are times when your child does need to have pull-out. There's certainly times when children are very discouraged and disheartened if they can't accomplish what their peers are accomplishing. Again, it's highly individualized. So here's what the continuum of services is. So it would be regular classes. There would also be pull-out, special classes, a special school, including private schools. If the school system cannot provide your child what he or she needs, then they have to send your child to a private school at public school expense. Because remember, your child's entitled to FAPE, and that's free appropriate public education. So if your child is sent in his IEP to a private school, that is free to you, including transportation. Home instruction, and then of course the most restrictive would be a hospital and institution. So again, IDEA is filled with procedural protections. So the IEP must be written annually, at least annually. The team must include the following people: the parent, the general education, special education administrators. Does it say teacher? I can't see my entire screen. And changes cannot be made without prior written notice to the parents. You have a right to examine all of the child's educational records. We call that a FERPA request. So FERPA, you can submit a request to the school for all your child's records. You have a right to request an independent educational evaluation. The school system has to provide you with the procedural safeguards, and that's the white magazine book that they have to give you at least once a year. You do not have to sign the IEP. In fact, I tell parents, do not sign the IEP at the meeting. This is an important document, and you want to take it home and read it and make sure it incorporates all of your comments, make sure it has all the goals you want, make sure all the accommodations are covered. It's essentially a contract, and you want to make sure that it covers everything you want. And you know, some parents feel pressure. There are schools that have said to parents, no, you have to sign it here. That's not true at all. If you don't feel comfortable, you can say, no, I have to show it to my spouse, or my sister is a teacher, I want her to look at it first. You can say whatever you need to, but I really don't recommend signing it at the IEP meeting. I would also tell you, for my clients, most of the time we sign in partial consent, which is something that is possible in Virginia. So in Virginia, the way the law is that the last signed IEP stays in place. So if, for instance, you signed an IEP for your child in first grade and you never ever signed another one after that, the first grade IEP would remain in place until they graduate. Obviously, that's not ideal. That means your child's not making progress. But for instance, and this is a double-edged sword, if your child is given a private placement that you are happy with, your child can stay there until you sign otherwise. So it has pros and cons. Places like Maryland, that doesn't have that same law, excuse me. They might be more willing to try a private placement because they know it's not permanent. Whereas in Virginia, once they give your child a private placement, they know they might never get the child back again. So it has its pros and cons. And then you must get the procedural safeguards. Okay. And I also suggest too, when we talked a little bit about self-advocacy, I like to have the children participate in the IEP meetings as much as possible. And I'm not saying to have, a kindergartner sit through a 2-hour IEP meeting. It's hard for kids of any age to hear all of the areas of need anyway. So there are many times when we will have a child as early as kindergarten come in and introduce themselves. And I usually like to say, everybody here cares about you and everybody here is working towards making sure you get what you need at school. And is there anything you feel like you need? And you'd be amazed. Kids, as early as 5 can say, I need to go take a walk every now and then. Or you can ask them what their favorite subjects are and what they struggle with, and they're very forthcoming. But this is something that's going to happen annually, and it can be very intimidating. And so I really suggest starting it early and then let them go back to their classroom. They don't have to stay the entire meeting. In fact, I don't really like young kids to stay the entire meeting. Like I said, it's hard to hear all the areas of need. So again, you're supposed to be partners in the special education process. I would be a fool if I thought that we were all equal partners. I think there's a tremendous imbalance of power, and schools sometimes take advantage of the parents' lack of information and lack of knowledge. Okay. So you have an IEP, your child's at their placement, and then it must be updated annually. So how do you prepare for your annual IEP meeting? So as I said before, you have your handy dandy 3-ring binder ready to go with all the documents in it, the progress reports, everything that you would need is in that binder. You would bring your child's current IEP. I like to chart IEPs, so I will chart what the goals are over the years so I can make sure the child is actually making progress. It's a big red flag if the goals are the same year after year after year. I might review what the proposed goals are, the progress reports, work samples. I ask if they do any reading assessments to see what level my child's reading on, have they made progress from last year. Input from your child, again, super important. We've had kids where the teacher said they'd like to sign the agenda that has the homework assignments of the student. And the student says, I really don't feel comfortable doing that. It would be embarrassing for me to go to the front of the room and have the teacher sign my agenda when they're not signing anybody else's. So, there's a fine line between doing what's best for your child, but also respecting your child's wishes. So I definitely think it's important to try to get input from your child. I also want to make sure that your child knows what their accommodations are. I've been to some school districts more rural where I had very little faith that the IEP would be followed. And so I was able to get a goal in that said, Billy will learn what his accommodations are and when to use them. And they actually, inside his notebook, he had a list of what his accommodations were. Because I really didn't think that he would get. And the accommodations are required. It's not optional. So if it says your child gets extra time, they get extra time without asking, period. So here's a sample. You can keep a list of your concerns. For instance, Billy spends 3 hours on his homework and his peers spend 30 minutes on the same homework. So I really recommend bringing a written list with you, because when you're in these meetings and you're outnumbered, you may forget some of these concerns that you have. Don't feel embarrassed or ashamed of going through the list. You can say, I have a list here and I'm not leaving until I finish going through this list and I want to discuss this. And then on another point, you don't have to go to an IEP meeting alone. A lot of people do have advocates or attorneys that come with them to help them navigate the system, but you can bring anybody who has familiarity with your child, and you are the one who determines that. So if your child, if the grandparent wants to come, bring the grandparent. If your child has a tutor, bring the tutor. Bring whomever you want. And these are all consensus decisions. And so frankly, it might help you to have some extra people sitting with you. but you get to decide if you're bringing extra people. So I believe you should share information with the school. If you do get private assessments, I strongly recommend that you share those, unless there's something in there that would be really, really a violation of privacy. I suggest that you share them. If you ever file a due process, all these documents are going to come out anyway. But I think it's really important also, depending on the situation, to regularly communicate with the school. So for instance, if your child didn't sleep the entire night, send an email in the morning saying, Billy had a horrible night. He didn't sleep and he didn't eat breakfast. He might be cranky today. You're also keeping a record. So for instance, if you have a child who is starting to demonstrate school refusal, you can send an email saying, I had to drag Billy to the car. He didn't want to go in the car and he's really doesn't want to go to school anymore. You're creating a record of all these instances. But I think it's important to communicate. The introductory letter is something I suggest to parents, that they send a letter to the next year's teacher. So when you find out who your child's teacher is, you can send a letter saying, you know, hi, I'm Billy's mom. We're really glad that he's going to be in your class. And Billy does have an IEP. And, you know, to get the school year off on a great start, here are some things that really help Billy. Billy does really well when he sits next to a positive peer role model. Billy does really well when he's allowed to walk around the classroom. A lot of times I will get written into the IEP that Billy needs to come in and meet the teacher before the open house. Those open houses are very daunting, and there are a lot of kids who just need separate, quiet, individual time with a new teacher to get acclimated before the school year starts. So just very quickly, I wanted to talk about some discipline. So if your child has an IEP, they have additional protections for if there's a discipline incident. So a school cannot remove a student who violated the code of conduct from the current placement. If there is a violation of more than 10 days, they have to do what is called an MDR, which is a manifestation determination review, prior to changing the student's placement. A change of placement would be even an out-of-school suspension of more than 10 days. That's a change of placement. So what is an MDR? Hopefully you'll never have to do one, but it is essentially a meeting that consists of similar people to an IEP meeting, and they will look to see if the misconduct in question was a manifestation of the child's disability. Because if it was a manifestation of the child's disability, then they couldn't help it and they shouldn't be punished for their disability. So again, it has to occur within 10 days. So the two questions are, was the conduct a result of the student's disability? And number two, which I don't see very often, was the conduct related to the school's failure to implement the IEP? Because schools don't like to admit that they didn't properly implement the IEP. But those are two discussions that you will have at an MDR. So what happens if you don't agree? So if your child is denied an IEP or 504 plan, you don't like the classroom or the school that they're requesting for your child is denied educational opportunities, your child's been mistreated, discriminated against, you disagree with the MDR, what can you do? So the informal parent options, refer to your special education guide. You can reach out to your parent resource center. You can make a public statement at your school board meeting, or every school district is supposed to have a SEAC, Special Education Advisory Committee. In Fairfax, it is called the Advisory Committee for Students with Disabilities, but I believe most, if not all, other school districts call it SEAC. They usually meet about once a month. They're required to meet 4 times a year. Or you can take a formal review, a formal option, which would be you appeal the decision. You can request mediation through something you can request through the Virginia Department of Education. You can file a state complaint with the Virginia Department of Education. There's instructions on their website how to do that. If there's been discrimination, you can file a complaint with the Office for Civil Rights, or you could file a request for a due process hearing. What can you hope to achieve? So the crux of most cases is that your child didn't receive FAPE, free appropriate public education. So you might say that your child's not in the right placement, they're not able to access an education, they're not appropriately ambitious goals, they're not receiving the services that they need to receive, or they're not receiving services that were documented in the IEP. You want to try to get a holding that the school system is not following the law. You might want to file a due process because you want a change in placement. You might want compensatory education. If you unilaterally placed your child in a private school, you really need to send what's called a 10-day letter, which is, I don't believe the school district is providing a free appropriate public education to my child, and in 10 days, I plan to withdraw them and send them to a private placement. You can do that, or at the IEP meeting, you can request private placement. If they won't give it to you, then you might have to make the difficult decision of unilaterally placing and then seeking tuition reimbursement. A lot of parents come to me and they want punitive damages. I'm afraid that's just not available under IDEA. So this was an interesting tidbit of information, and it's from 2011 and 12. There is a lag and sometimes in getting information updated, but you can see that there aren't very many due process complaints compared to the other options. So written state complaints that year, and these numbers I think have increased significantly since 2011. So there were 135 state complaints, 125 requests for mediation, and 45 requests for due process. And what's interesting is, remember, there's 45 requests for due process that year. And then if you look at my table here, only 5 of those in 2011 and 12 went all the way to a decision. So if you file a due process complaint, there's a mandatory resolution meeting that has to occur. You can also participate in mediation when you're in a due process complaint process. So there are opportunities to settle or resolve the issue, even in a due process situation. I really cringed. I cringed when I had to make this slide because I really want COVID-19 to just be behind us. But I felt like it was important to talk about life with COVID-19. It's just a reality. So the CARES Act offered the US Secretary of Education at the time, Betsy DeVos, an opportunity to request waivers. And she affirmatively declined to request waivers, which is probably one of the few decisions that I agreed with. And she said, while the department has provided extensive flexibility to help schools transition, there's no reason for Congress to waive any provision designed to keep students learning. With ingenuity, innovation, and grit, I know this nation's educators and schools can continue to faithfully educate every one of its students. So she said all timelines and deadlines must remain intact, although realistically, most can be modified by mutual party agreement. Again, parent participation is still critical. And it's been very interesting in the pandemic because I have a lot of parents who now have a window on the classroom. So for years, they've been told that Billy is just slightly behind his peers. And now the parents are right there alongside Billy while he's doing virtual learning, and they're seeing woefully behind. So parents are really critical at this time because you are the one who can talk to the progress or lack thereof. Parents must be afforded opportunity to participate in IEP meetings still. That means they can't mute you. You have to be able to participate. And this has always been the law, that parents can participate by telephone or video conferencing, because parent participation is that important. So if you can't make the meeting, you are allowed to participate by telephone and video conferencing. And that's not just during COVID-19, that's all the time. So the due process resolution meetings can also take place by telephone or video conferencing, and due process hearings can be held virtually. What's interesting is that our firm has had, I believe, at least 2 hearings since COVID started. And I know the first one we had, interestingly, was in person. And the second one was virtual. And I think that there's some really advantages to being able to have virtual, because you can then have virtual testimony. So if you had a practitioner or a school member who was out of state, they can participate virtually. So there's been some advantages to compensatory education versus recovery services. And I put recovery services in quotation marks because the law does not define recovery services. This is a creation that resulted from COVID-19. So I don't even like to really talk about recovery services because I don't believe that such a term is appropriate. But what has happened is the school districts feel that compensatory education has a punitive quality to it, because compensatory education is usually ordered when a school district fails to provide something. So school districts don't want to be blamed for compensatory education during COVID, so they created recovery services. Ultimately, it doesn't matter what it's called as long as a child gets what they're entitled to. But neither compensatory education or recovery services is hour for hour. So you can't look at it and say, Billy got 2 hours a week of speech and language services. During COVID, he got half an hour. Therefore, he's entitled to 1.5 hours a week for all those weeks that he didn't get the 2 hours. It doesn't work like that, and it's never worked like that. It's pretty much what does the child need to get them to the place that they would have been had the omission not occurred. So it's never been an hour for hour replacement. And in order to get these recovery services, you need to convene an IEP meeting and talk about where your child should have been at this time. And so that's why the Andrew F. case is really important. And it's really important to document your child's present levels and their rate of progress, because you can look and see if they're woefully behind in meeting their goals, then they've had a lot of challenges. There are a lot of kids who have done very well this year. There are kids who have, especially kids who have social challenges. There are children who have really thrived because they haven't had to worry about navigating the social world. And so they're able to focus on academics. But that doesn't mean that goal, if there's a social skills goal, the goal should not be removed. And I think parents too, it's really important that you can document your child's progress because you have a window on what's happening right now. So don't let the school district offer you ESY services. That's not supposed to be a replacement for recovery services. And I also want to clarify, this is a pet peeve of mine, that ESY stands for extended school year. It's not summer school. Summer school is different. And ESY is not just a summer educational opportunity. ESY is any time that school is ordinarily not in service, in progress. So ESY could be on Saturday and Sunday. ESY could be over winter break. ESY could be over spring break. So anytime there's a risk that your child would regress, they could be entitled to ESY. So, and the dates and hours cannot be predetermined by the team. It's 100% a child-based decision on what your child needs. So again, keep data on your child's progress or lack thereof, and call an IEP meeting and say, my child did not make appropriate progress in this area and we need recovery services. even though I don't like the phrase recovery services, but recovery services has the same challenges as compensatory education, which is when do you do it? I mean, your child is in school, let's say until 3 o'clock or 3:30. Do you really want them to stay until 5 o'clock to get extra services? Do you really want them to go to school 7 days a week? So it can be very tricky to get to figure out when to do recovery services. So I'm going to wrap up with your top 10 takeaways from this session tonight. Hopefully you got some good information. So parents can initiate the special education process. You don't have to wait for the school. Remember, send that email, ask for help. Invite your child to be part of the process. Have them come to part of a meeting, have them give input on the IEP, have them familiarize themselves with what accommodations they're entitled to. Parents are integral members of the IEP team, and I remind IEP teams that all the time because they do outnumber you. The prior written notice document must be provided to parents. Keep all written communications. Students with disabilities have additional protections and disciplinary actions. Don't go to the IEP meeting alone if it makes you uncomfortable, and it helps with numbers if you have people with you. Don't sign anything till after you have taken it home and reviewed it. And special education is a cooperative, collaborative process. And the number one takeaway is you are your child's advocate. And so trust your instincts. This is one of my favorite quotes from Albert Einstein. Everybody is a genius, but if you judge a fish by its ability to climb a tree, it will live its whole life believing it is stupid. So we don't want any kids believing that they're stupid. So here's my contact information. I am not able to see the chat, but I'm sure I can if I stop my screen sharing. But Kayla, if Kayla is here, Kayla's here. So maybe Kayla wants to, let me stop the screen. Kayla wants to go through any of the questions that were in the chat.
Yeah, for sure. Thanks, Sherry, for your presentation. I know I learned a lot, and I hope everybody on here has some takeaways too. A question that was submitted ahead of time was a question about navigating special education. And that question was, what do you do when your team dismisses the multiple diagnoses your child has and tells you they won't evaluate for those disabilities until they've tried everything else, even though you've been down that route in pre-K, and is condescending in every meeting? Are there other avenues besides going through the elementary school you're zoned for? And that was the question.
Right. So, and that question has probably like 15 sub-questions in it. Because it has a question about pupil placement, changing, elementary schools. So, and those are things that I really can't answer. You can try the pupil placement route. If you're not happy with your elementary school, you can petition to have your child placed in a different school. I don't know that you'll get a different result. You can bring an advocate or an attorney with you. I can't promise anything, but I can tell you I have never gone to a meeting for a child who's not found eligible. I've been at meetings where the parent was just at the eligibility meeting, and I've literally joked that the child must have just caught the dyslexia in the pool, because 3 weeks earlier they were not found eligible, and then suddenly I show up and now they're eligible for a specific learning disability. So you can get an IEE. Did she say that she had gotten a private evaluation?
I don't believe so. Oh,
so okay. So if you got a private evaluation, and so the trick is the law says the school team must consider a private evaluation. That means they can consider and reject it. And so the law is just written in a way that you don't get all the full force and effect of a private evaluation. So I would suggest in that case is to either get more data, more information, request a pupil placement if you'd like, or you might have to take more formal steps like filing a state complaint or filing a due process. But it's very hard to give specific legal advice on a case that you just got a sliver of, a little bit of information. So if the parent wants to give more information, I'm happy to hear it. But it is very difficult. And I will caution, though, in Virginia, the pupil placement needs to be reviewed annually. And you do run the risk that it could be withdrawn. So if your child is granted a pupil placement and both principals have to agree that the child can go to the other school, they could decide in a year that, the new school could decide that they're now overpopulated and the first kids that are going to go are the kids who've been pupil placed. So, and there's also other problems with pupil placement because your child's no longer in the school with their friends and neighbors. And I know a lot of socialization occurs on the school bus and kids make plans together, and group projects are harder when your child's out of district, out of bounds. So, if you want to, I don't want to put the mom on the spot.
I ended up reaching out to an advocate and then emailed again. And so basically I wasn't told that evaluation was even an option, that they just wanted to wait and have him in the general ed classroom and evaluate them himself. So my son is 5.5, but starting kindergarten in the fall. And we got the dyslexia diagnosis. He has ADHD. We were wanting to get ahead of the game and have something in place when he started, and potentially with the dyslexia diagnosis, some, services over the summer if that was available. I reached out and they were like, well, we've never met him before, so we have to wait until he starts kindergarten and do it then. And so I called an advocate and asked to have him evaluated anyway. And when I told them that, they said, oh, well, we can have another meeting. And I said, okay, well, can you please include my advocate in that meeting? And all of a sudden they said, yeah, we'll be discussing starting the process for the full comprehensive evaluation. So
okay. Oh yeah, it's terrible. I'm the first one to say it's very sad. It's a sad system, but you need to pay attention to the timelines, because I've had plenty of parents who've spoken to their special education administrator and said, my child has dyslexia and needs help. And the administrator says, they're too young. Let's talk about it next year. That's a violation, because just the request starts that timeline. And so you need to pay attention to the timeline. So any evaluations that they're going to do have to be completed within 65 business days. Actually, fewer than that, because they have to give you the copies of the assessment at least 2 days before the eligibility meeting. So the whole process needs to be completed with 65 business days, which I said earlier is about 91 calendar days. So good for you. Okay, there are other questions?
We do have another question from Navara. I know that she's still on here, so she might have further clarification, but she said in the chat, my son has an IEP, but I do not think it is working for his benefit, and I want to reduce the amount of time he spends in special education. He's in the START program, gifted, and most of his need is impulse control, disruptions, but she feels like he's not growing socially and is missing out on the true classroom experience. Is this something that's difficult to change? And then she said they used to pull him out towards the end of the day, which was fine, but they upped the amount of time of the now special class, and she wants to have him back more in the general class.
Okay, so again, that's many questions rolling on. I would start by asking if they've done an FBA and a BIP, because if your child's having behavior issues, that's the first thing that I would want to look at. And an FBA, functional behavior assessment, will look at what's the antecedent that's causing the behaviors. For some children, it is overwhelming to be in a large classroom, and that alone can cause behaviors. For other children, being in a small self-contained classroom can cause behaviors. So you'd want to look at what's causing the behaviors and then put goals into the IEP that specifically address those behaviors. If the child's having socialization issues, then I would put socialization goals into the IEP. I don't exactly know the child's background and the details, but for instance, a goal could be that Billy will have reciprocal conversation with classmates on a topic of the classmates choosing. So that way, if your child is like, consumed with Minecraft, is that it? All the conversations aren't about Minecraft. They have to learn how to have conversations about other people's interests, or even if they're working on a group project, a willingness to accept others' ideas. So there are an infinite number of goals that you can come up with that will target that behavior. And if they're seeing that in class, then that is something, obviously they see something because it made them want to put him in a different classroom in a more restrictive environment. And if you sign that IEP, then that is what they're supposed to provide. So you would have to go back to an IEP meeting and have that service hours change. So he could maybe get some service hours in the gen ed classroom, or even maybe some pull out so he can have some counseling hours, or working with a school counselor, he can have contrived situations and work on that. It just depends on where he is in his development.
Yeah, so what they did, he's had an IEP since kindergarten, which I'm sorry, Jacqueline, we were able to get all that straightened out through the county like fairly quickly. So I'm sorry that they made you do all that. In kindergarten, they have an aide, so there was no need for a pullout. So then in first grade, that aid goes away. So any disruption became way more noticeable, obviously, and there was not another person that could do that. This teacher was different. And so, my dates are he is now in second grade. So in first grade, they upped the amount of time that he would spend in the special education classroom. And I kind of just did it because I thought they all seemed so nice, and they were thought that they were doing what's best for him. The problem I am seeing is that my son is not an intellectual. He's smart. He's really smart. Like most kids, he has preferences. His is math and science, and that's his jam. So he is in the START program. The teacher, that same kindergarten teacher, had him tested for that because she realized that and saw that and all that other fun stuff. His behavior, I don't see, is changing because every single kid in his class has the same disruptive tendencies. He is not being exposed to how he should be behaving in class. Since we are virtual now, for second grade, he's in math in a gen ed, and he follows that same gen ed class from math to encore. So it's like 2 classes. Since we've been home, I have not noticed that he disrupts any more than the other second graders who are cutting the teacher off, and she has to keep putting them on mute and telling them to wait their turn. So we are about to be at the time of year where I'm going to get a call to the meeting for the annual IEP. I would like to increase the amount of time that he spends in the gen ed class. And then also the teachers in the gen ed are doing, I don't know if this is, anyway, they're doing the 100-day, they're doing field trips, they're doing projects, they're doing like these group assignments that he is not able to do in this small classroom. He's missing out, I feel, on that particular socialization aspect as well. I want to increase, I'm sorry, yeah, go ahead.
Yeah, go. So I would really recommend that you talk to them about the least restrictive environment. And it sounds like your son is what we call twice exceptional. Are you familiar with that phrase?
Just like the past 6 months or so, yeah.
Okay. So if he's twice exceptional, then he's more likely to get the challenging academics in the gen ed environment than he is in a small special ed environment. It's not supposed to be like that, but that's just the reality, that the small special ed classrooms tend to not necessarily have the same curriculum or the same depth of curriculum or the same challenges. And that could impact his attention. If he's not being challenged, then he will start having behaviors and will start, losing attention or interrupting the teacher or things like that. So, but he could have goals for those things. He could have goals for not interrupting the teacher. He could have an IEP goal that says, he will, not, in the classroom for a non-preferred topic, he will refrain from interrupting, or he will stay on task. I don't really like to do negative goals, but he will stay on task without interruption, that kind of thing. Because there is an argument to be made that his behaviors will improve when he's academically challenged. I also do think that kids emulate behaviors of other children. So he probably will start to emulate the behavior from the kids whose behaviors you don't want him to follow. But you can ask for the FBA as well, functional behavior assessment.
I think they did a bit.
Did they do the BIP?
I think they did the BIP, but I want to say they did it. The behavioral.
It's a behavior improvement plan.
Yeah. I have to go back and grab my form and see what it says.
So I think you just need to be persistent, and at the IEP meeting say he really needs that to be with, he's acting up because he's not with the neurotypical class, and he really wants to be with the Gen Ed class. And it's very tricky to navigate because there are kids who are twice exceptional who are academically gifted, but also require a small classroom setting. That's just not, regularly available in Virginia. So it's very.
And they had mentioned, we thought that the curriculum was the same, that in his class, there's first, second, third, and that whatever the teachers were teaching in a regular second grade class was also being taught, but it's not. And it's not, and I'm seeing it now, like even his math, because with COVID, everything took a little time. So he was in there for math. It took a while before he got to his math teacher this year. And when he got into that math class, how she was teaching and what she was teaching was totally different than what the special ed teacher had been teaching and how they had been teaching it.
Right.
So that was concerning.
Well, and I see that quite frequently, and there's also, even in the high school level, they have team taught classes, and they say the material in the team taught class is the same in the Gen Ed class. And my experience is that it's not. The team taught class tends to be go at a slower pace. For someone who's gifted, you might want to look into one of the gifted and talented programs, because that would allow him to explore things and give him more opportunities than he would in a Gen Ed environment. But it could just be, and it could be the teacher, it could be a lot of things and you can certainly ask your son, what is he like? What does he not like? And, just sort of off the cuff advices, I would really push for more inclusion. And even if they have documentation that in the Gen Ed classroom, there are fewer outbursts than when he's in a special ed classroom, that would be a good data point to show that his behavior is better when he's in a Gen Ed classroom.
Thank you.
My pleasure.
Sherry, there were no additional questions in the chat, but I just want to say thank you again for your time this evening and for all that you do for this community.
Oh, thanks so much for having me, and thanks to all the parents who took time out of their busy schedules to join us. And hopefully we'll be back at the Circle of Support next year and back to some normalcy.
Certainly. Well, thank you everyone for coming this evening. Jan Russell will be sending out Sherry's slides as well as an evaluation for the workshop. And again, thank you. Hope you all have a good week.
Yeah, have a great week. Thank you.